Welcome, everyone. And thank you for joining us for this webinar on the human right to a healthy environment. Just to frame things a little before we hand over to the speakers. When we conceived this series on eco-law, initially I wasn't sure whether to include the human right to a healthy environment, because we'd been looking at more emergent laws, rights of nature, the proposal for a law of ecocide. And on one hand, I felt, well, this is still a very anthropocentric way of looking at things, you know, the human right to a healthy environment, as opposed to what about nature's rights? But actually, I think the fact that we are at this point, so in the original Universal Declaration of Human Rights, there was no mention of a human right to a healthy environment. It was a right to life is in there, but nothing in relationship to the environment. So I think this, you know, we're also seeing an emergent trend here with human rights, and I thought that would be really good to explore. Also partly because our first speaker, David Boyd, has written a book about rights of nature. So he's in a very good position to look at both, as is Cormac. But yes, this interface, we know there are so many millions of people living in the world who don't have a healthy environment to live in and suffer greatly from it. We have 7 million premature deaths every year just from air pollution. That's huge. So, you know, this is a massive issue faced by so many human beings, but also, of course, we see the impacts of the devastation of nature as well alongside it. But I won't witter on anymore. I'd like to introduce, well, actually, I'll frame this just if you want to put questions in the chat. What I'd like to do is save them up until the speakers have presented, and then we'll go through that as a Q&A. And you might want to address one person, and then I could open it up to other speakers to comment depending on the question. So please do feel free to put your questions into the chat. Each speaker will speak for about 15 minutes, and then we'll have a Q&A at the end after the 4 speakers have spoken. So we will start with Dr. David Boyd, who I'm delighted to welcome today, and he is the UN Special Rapporteur for the human rights and the environment, and he's the author of many books. He is an associate, let me get this right, a professor of law, policy and sustainability at the University of British Columbia. And I won't say any more, David. You could introduce yourself as you like, but I'll pass over to you now.
Great. Thanks very much, Lisa. And it's a great pleasure to be with all of you this morning. It's very early here on the west coast of Canada, which is why the lighting's a bit funky. And I'll also say thank you to everyone for taking the time out of your busy schedules to join us, and especially given that Spain and Morocco have just kicked off in the round of 16 at the World Cup. So as Lisa mentioned, I think everyone on this webinar probably is well aware of the fact that we're in the midst of an unprecedented planetary environmental crisis. The climate emergency, pollution, which, as Lisa mentioned, kills 7 million people a year through air pollution alone, and millions more through exposure to toxic chemicals, and the collapse of biological diversity. I mean, 1 million species at risk of extinction, wildlife populations down by 70%. And from my vantage point, this global environmental crisis is also very much a human rights crisis. It's the environmental crisis has impacts on the rights to life, to food, to water, to cultural rights, the rights of the child. And so that's why a decade ago, the United Nations Human Rights Council set up a special rapporteur mandate on human rights and the environment, appointed Professor John Knox. And John spent 6 years really connecting the dots, which hadn't been done to a great extent previously, connecting the dots between human rights and the environment. His mandate was called, he was actually started out as the independent expert on the state obligations related to the enjoyment of a safe, clean, healthy, and sustainable environment. And note the missing word there, no mention of the word, the right to a safe, clean, healthy, and sustainable environment. And that's because in 2012, that right had not been recognized at the global level, had never been recognized by the United Nations. And so John's work over the 6 years from 2012 to 2018 really laid a foundation for the recognition of that right. And then when I was appointed to succeed him in 2018, that was my top priority, was securing finally something that people had worked on for decades, which was United Nations recognition of the right to a clean, healthy, and sustainable environment. That happened in a resolution adopted by the UN Human Rights Council in October 2021, and then that was followed by a resolution at the UN General Assembly in July of 2022. So it hasn't yet been added to the Universal Declaration of Human Rights, but we can say with some degree of confidence that the right to a clean, healthy, and sustainable environment is now a universal human right. And that's really important. It's also important to recognize that it's not a new human right. Really, environmental rights and responsibilities have been part of indigenous legal systems for thousands of years. And across the world, there are more than 155 nation states that had already recognized the right to a healthy environment, either in their constitutions, as is the case in South Africa, Argentina, many other countries around the world, over 100 countries today. There's also over 100 countries where the right to a healthy environment is included in environmental legislation. And there are more than 130 countries that are parties to regional treaties that include the right to a healthy environment, such as the Aarhus Convention, the African Charter on Human and People's Rights, the San Salvador Protocol to the American Convention on Human Rights. So while the United Nations kind of is late to the party, we have decades of experience with the right to a healthy environment. And so my work as the Special Rapporteur on Human Rights and the Environment has really been to advance the recognition of that right at the UN, and also, I would say even more importantly, to accelerate the implementation of that right, because ultimately words on paper don't protect the environment unless those words are put to use by people. And so I've produced a series of reports to the Human Rights Council and the General Assembly on the substantive elements of the right to a healthy environment. What does it actually include? And so 6 reports covering clean air, safe and sufficient water and healthy aquatic ecosystems, healthy and sustainably produced food, non-toxic environments where people can live, work, learn, and play, healthy ecosystems and biodiversity, and a safe, livable climate. And each of those reports really lays the foundation in terms of what are government's obligations when it comes to protecting the right to a healthy environment. And from the perspective of this webinar, I think one of the most exciting developments is that increasingly the right to a healthy environment is being interpreted by governments and courts in an ecocentric fashion, which means it's not only protecting the health of human beings, which it clearly does, because we have to have healthy, clean air, clean water, and avoid exposure to toxic substances for human health. But also this right is being interpreted in an ecological way to include the health of nature. And probably the most important case in this regard was a decision an advisory opinion of the Inter-American Court of Human Rights in 2017, where they really clearly articulated the way that this right to a healthy environment is different from every other human right because this right protects nature. And that decision of the Inter-American Court has been followed by courts in Colombia, in Costa Rica, in Mexico. In Mexico, for example, a case involving a tourism development that was threatening a mangrove ecosystem. And again, the Supreme Court of Mexico said very clearly that there are 2 elements of the right to a healthy environment: the health of humans and the health of ecosystems. So that's a very exciting development. And in my role as Special Rapporteur, one of the ways, in addition to these reports to the United Nations, one of the ways I've been attempting to advance the implementation of the right to a healthy environment is by intervening in court cases around the world as a friend of the court, an amicus curiae. So I've done that in about a dozen cases so far, in Brazil, in Norway, in Indonesia, in South Africa, and also in regional and global tribunals. So recently a case before the Inter-American Court of Human Rights, which will be the Inter-American Court's first opportunity to address the issue of air pollution and toxic substances, and what are the state's obligations because of the right to a healthy environment to protect people from air pollution and toxic substances. Also, a couple of cases before UN treaty bodies. So a case before the Committee on the Rights of the Child about climate change, another case before the UN Human Rights Committee about climate change. And that case is worth mentioning because the UN Human Rights Committee recently determined that Australia was violating its human rights obligations to the Torres Strait Islanders, a group of indigenous people living on islands off the coast of Australia, by failing to take adequate adaptation action to protect the rights of those people. And I think this is where human rights have such great promise, because in the world of international environmental law, we have literally hundreds of multilateral environmental treaties. But the Achilles heel of international environmental law is a lack of compliance and enforcement mechanisms. So for a country like mine, Canada, we've made commitments for decades to reduce greenhouse gas emissions. We've never successfully achieved any of the commitments we've set for ourselves because and we've never been held accountable. The only means of accountability is to vote the scoundrels out at the next election, and that's a very difficult way to hold a government accountable. But human rights offer both processes and institutions through which governments can be held accountable, and those human rights processes have already proven to be successful to some extent in accelerating climate action and catalyzing more ambitious environmental progress. You have the famous Urgenda case in the Netherlands, where the Supreme Court of the Netherlands ordered the government, because of its human rights obligations, to take faster, more ambitious action to reduce emissions. Similar cases in Germany, in Belgium, recently in the Czech Republic. In Colombia, we had a case brought by 25 children and youth based on their constitutional right to a healthy environment, where they argued that the government's failure to prevent deforestation in the Colombian portion of the Amazon River watershed was a violation of that constitutional right to a healthy environment. And they were successful in that litigation, with the court ordering the government to bring together the children and youth, the country's leading scientists, government agencies, and come up with a plan to stop deforestation in the Amazon rainforest. So I think these types of cases are very encouraging. Obviously, there's an incredible amount of work to do. And going forward, now that the United Nations has recognized this right, I'm really trying to advance my efforts in two main tracks. One is continuing to strengthen the legal tools that are available. So there's a process currently ongoing at the Council of Europe to add an additional protocol to the European Convention on Human Rights, which is the only regional human rights treaty in the world that does not yet include the right to a healthy environment. Also trying to ensure that this right to a healthy environment is incorporated in international instruments, such as the new treaty on plastic pollution that's currently being negotiated, also the new treaty on pandemic prevention, preparedness and response that's under negotiation. And even next week, I'll be in Montreal pushing for the inclusion of the right to a healthy environment in the post-2020 Global Biodiversity Framework. So strengthening the legal tools, and then, as I said, the critical step of advancing implementation and using all of the tools at our disposal to make that happen. So I don't want to speak for too long, because I know there's lots of people will have questions, but I do think this is a very exciting time, and obviously the stakes could not be higher. The reality is this planetary environmental crisis that I mentioned has disproportionate impacts on communities, populations, and countries that are particularly vulnerable. So for example, in the context of the climate emergency, small island developing states, low-lying coastal nations, low-income countries, and human rights provide not only a catalyst for more ambitious action, but a way to focus our attention on those people who are most vulnerable, who are in danger of being left behind. So I'll leave it at that. Thanks very much for having me today, and I look forward to the Q&As and also to listening to the other speakers. Thank you.
Thank you, David. It's really fascinating. Sounds like you must be extremely busy with all your work, I imagine. It's one thing that it occurs to me, it's interesting to me that we talk about human rights, but where do the duties come in? Obviously in national environmental laws, you're under a certain duty to not do things, but I don't think we've sort of framed that at an international, what are our duties, for example, to not pollute or to keep ecosystems healthy? Anyway, I just threw that in there because I was thinking of it.
Yes,
So
if I could,
yeah.
I'd love to just say that that's exactly the question that my reports to the General Assembly and the Human Rights Council on these substantive elements of the right to a healthy environment endeavor to answer. And fortunately, for example, in the context of air quality, I articulated, based on decades of jurisprudence, 7 clear steps that states must take to protect citizens' right to breathe clean air. And courts around the world are beginning to implement that framework. So I think that that's a very important question, and we do have the answers.
Yeah, thank you. So we'll move over to Sue. Just to introduce you, little Sue. So Sue Willman is Assistant Director and also lecturer at King's College in the University in London. And she launched the UK's first human rights and environmental legal clinic. And she's also a member of the King's Centre for Climate Law and Governance. So I'm really excited to hear about Sue's work with the legal clinic and what she's focusing on at the moment.
Hi, everyone. I'm really grateful to Earth Lawyers and Consensus Law to give me the opportunity to talk in such good company about the cases that we're working on at the Human Rights Environment Clinic at King's College in London. So we work on cases that cross between the human rights and environmental law intersection, especially those cases which David alluded to, where the activities of the global north are adversely affecting the global south. I hope that talking about 2 of those cases might inspire some of you, and if you have any thoughts or suggestions about the work, do get in touch. So I'm going to start my talk in Africa because, as David said, Europe is lagging behind. So far, the Council of Europe has only managed a recommendation about the right to a healthy environment, whereas both the Inter-American system and the African Charter have had those rights enshrined in law for many years. And that fact led me with Harry Balfour-Lynn, who's in the webinar, to start a project called the Environmental Rights Recognition Project. It's based in the clinic, and we're trying to promote, from the UK, we're trying to promote this idea of a new European convention right, a new right to be added to the protocol. Iceland is responsible for the Council of Ministers at the moment, and they have said that it's a priority for them, but we're keen that other states and individuals should support them and try to push forward that right, because simply having a recommendation rather than a protocol right we think is not good enough. Anyway, going back to Africa, the African Charter on Human and People's Rights has got both the right to health and to the environment. Article 24 states that all people should have the right to a general, satisfactory environment favourable to their development. But simply having a right in regional treaties isn't really enough if we want to get to enforceability, which again David mentioned. And one of the 101 states where the right has been incorporated into national legislation is Uganda. It's in Uganda's constitution, and it's also been mentioned in case law. For example, there's a case called Greenwatch against the Attorney General, in which the Ugandan court recognised the distribution and sale of plastic bags could be a breach of the right to a healthy environment. So the clinic got involved in Uganda at the request of Greenwatch. They're a very effective NGO of environmental lawyers, and they were concerned about deforestation. Uganda previously had massive coverage of rainforest, which of course was useful as a carbon sink, biodiversity, a place where indigenous people live, etc., etc. But forest cover's fallen from 24% in 1990 to 10% of the country in 2017. So every year, more and more forest is being lost. And they asked us if we could intervene in a case that they were bringing in the Ugandan High Court against the Attorney General and forest authorities. The case is asking the government basically to stop degazetting of the forests and to take more steps to protect the forest. And we've helped them in two ways. First of all, geography students at King's, supervised by Professor at Macquarie University, investigated the impact of deforestation. And it was interesting that the geography PhD candidates professor found it wasn't just about climate change and biodiversity, the obvious impacts. Also, it caused heat waves, it caused drought, it caused forest fires, landslides and mudslides, flooding, soil erosion, and of course, lost habitat and agriculture. So we are about to file a legal amicus arguing that present and future generations of Ugandan citizens enjoy a constitutionally protected right to life and a right to healthy environment, and that is breached by the destruction of the forests and the resulting climate change and these other damages, and that should oblige the forest authorities to take remedial steps. So I'm going to come back to Europe and look at a case in Serbia. And one of today's questions is whether the right to healthy environments simply means a human right, or does it mean a right of nature? And I can't take any credit for the argument behind this case, which is really focused on the right of nature. I have to give it to Zoe Lujic of Earth Thrive, an NGO which is based in the UK but has Serbian roots. Serbia has got a right to a healthy environment like Uganda, and apparently 2/3 of its citizens are in favour of the right, but a lot of money is needed to be invested, according to the UNDP, $1.5 billion to get there. And in the meantime, Serbia is rapidly expanding its mining sector. It's trying to double the mining sector. So let me take you to a little village called Karamanica, which is near the Bulgarian and Macedonian border. And along comes a British mining company which wants to explore for copper, zinc and lead. And the clinic students and external barristers worked on a legal complaint using the Berne Convention. The Berne Convention, which is housed in the Council of Europe, in its preamble recognises the intrinsic value of wild flora and fauna, and Article 4 requires contracting parties, like Serbia, to take appropriate and necessary legislative and administrative measures to conserve the habitat of wild flora and fauna species and endangered natural habitats. So the idea, really Zoe's idea, was that we could bring a complaint to the Berne Convention Secretariat against Serbia. And as with all of these complaints, much of it is about raising awareness and drawing attention to the issue and using political pressure. But she wanted to do it from a rights of nature perspective. Obviously, there's a question, the right to healthy environment of the local community, but also there are a number of endangered species. And I'd like to just mention those. I might get a bit emotional about this, but I think it's always important just to think about what it is we're talking about. So we have black pines, we have yellow-bellied toad, agile frog, European tree frog, Mediterranean tortoise, green lizards, sand lizards, dice snake, nose-horned viper, Macedonian crested newt, the semi-collared flycatcher, the bird. There's a fire salamander, a stream frog, a lake frog, a grass snake, alpine newt, and others. And we've brought a complaint arguing that the Serbian government's decision to allow mining in these locations with arsenic, cadmium, lead going into the water supply has resulted in damage to the environment, and that's in breach of its international obligations under the Berne Convention, and possibly also under the Convention on the Conservation of Migratory Species of Wild Animals. We filed the complaint 3rd of October, and it's going to be considered by the Secretariat with another complaint in relation to mines in the Homolja Mountains region. So I thought it was useful to have a look at those two contrasting complaints, one from a mostly anthropocentric perspective and the other from a more rights of nature perspective. And hopefully this will lead into what Cormac has got to say about the rights of nature. Thank you.
Thank you, Sue. That's really interesting to hear about those cases. We will just go straight into Cormac. If that's all right with everyone. We have a few questions which we'll save to the end. Please do ask more in the chat if you would like to. So Cormac has been a practicing environmental attorney and is an author based in Cape Town in South Africa. He is a director of a South African environmental law firm, Cullinan and Associates, and the director of the Wild Law Institute, which is a non-profit organization that advocates for rights of nature. I know Cormac through the Global Alliance for the Rights of Nature, where we've both been civil society judges for the Tribunal for the Rights of Nature. And I also know him because he sort of blew my mind a number of years ago when I read his book on wild law, which for any lawyer is a kind of whack on the side of the head, let me say. In terms of how we humans conceive our place on the planet in relation to basically our relationship to the rest of Mother Earth and other species. So I will stop there and let Cormac continue. Thanks, Cormac.
Thanks very much, Lisa. So I'm going to speak a bit about human rights and nature's rights. Now, as all of you will know, almost all legal systems are essentially anthropocentric. In other words, they're focused on human beings and based on the assumption, really, that we're the most important creatures in the universe and that everything revolves around us. Now, so from an anthropocentric perspective, obviously, humans tend to be set up as being separate from nature. And so we talk about humans on the one hand and the environment on the other. And they don't overlap. And that leads to the idea that human rights get contrasted with rights of nature. So the perception is created that not only are human rights very distinct from rights of nature, but they are potentially in conflict and that there's some kind of balancing that has to be done between the two. And obviously, all the rights, the formulation of a right to a healthy environment still falls within that essential approach. It's a human right, it accrues to humans, and it's a right really to, in a sense, be given something. But it is, of course, very important, as all human rights are, because it enables individuals to rely on it to protect themselves against the state, or to require the state or public bodies to take certain actions. So it's a particularly important right in that respect. And as you heard David say, it's increasingly being interpreted in a wider way. But to talk about the nature's rights or the rights of nature, it's not necessary now to shift to an ecocentric perspective. So this ecocentric perspective in philosophy of law is often referred to as earth jurisprudence. So I'm just going to talk a few minutes about that before I'm getting into really the differences between human rights and nature's rights and the similarities. So from an earth jurisprudence perspective, as Thomas Berry used to say, the universe is the primary lawgiver. In other words, we've come into being, come into existence within an ordered universe. everywhere we see structures of order, whether it's how the planets move within our solar system, or how an individual plant may organize itself internally, etc. So from this perspective, law is very close to self-ordering, the process by which beings make themselves and self-regulate themselves, and then ecosystems, etc. And from this perspective, we are but one creature in a community of life, which we could refer to as the Earth community. And that community is created by the interrelationships between all the aspects of it. So we are hopelessly entangled with life and with everything else in the universe. And we are one form of life. So life flickers through the universe and it produces different life forms which arise and then fall away. So the purpose of rights of nature, perhaps I would argue the strength of the rights of nature approach is, first of all, it confronts a person who has been brought up in an anthropocentric legal system with the idea that there might be other beings, other subjects of law capable of holding rights than humans or corporations or the state. So when you first hear the idea, it jars, because we are taught in law schools that only a legal person, such as a corporation or a human being, may hold rights. So as soon as you say rights of nature, it's forcing the confrontation with the reality that there are many beings in the world with whom we have co-evolved. And our relationships are not just with humans, but of course with these other beings, etc. The second, I think, important thing is then it gives rise to the human duties to respect and uphold those rights. So a river doesn't really care whether you think it's got rights or not. It just does what rivers do. But as soon as we, in our human realm, recognize the river has rights, then there are corresponding duties on humans to give effect to those rights and to uphold them. So the real impact is to recognize, is to create, if you like, the duties on humans to relate in particular ways to other beings within the community of life. And that, of course, also shifts to looking at relatedness. So environmental law typically looks at aspects of the environment as objects. We set specifications for how much pollution there can be, etc., etc. We don't often look at it in terms of relatedness and the quality of relationships between humans and nature. But this approach shifts to that. And so, for example, if you look at the Universal Declaration of the Rights of Mother Earth, that was adopted in 2010 in Cochabamba in Bolivia, although it begins by specifying the fundamental rights of Earth and the components of Earth, more than half of the declaration is actually the duties which are imposed on humans and human institutions to respect those rights. So what are some of the implications of this perspective? Well, first of all, from this perspective, because humans are not separate from nature, but are part of nature, human rights, or at least fundamental human rights, are a subset of nature's rights. So conceptually, it's not that you have human rights separate from and superior to nature, but in a way, they're more like fundamental rights to life to be, are within rights of nature. If you like, you could see human rights as a species-specific articulation of rights of nature. That's not to say that all human rights are absolutely fundamental. You know, some are to do with perhaps political rights, etc., which may vary from country to country. But the fundamental rights, I think, which are about protecting the right of humans to give full expression to their humanity, to unfold as full human beings. Those kind of fundamental rights are, I would argue, a subset of the rights of nature. And they're fundamental, like other rights of nature, in the sense that all of them are oriented towards enabling the members of this community of life, this extraordinary community of life we call Earth, to come into the fullness of their being, and in so doing, contribute to the health, vitality, integrity, and beauty of the whole community of life. Now, it also raises the question of limitations, because all rights are limited, and human rights are limited in ways which are necessary to ensure that to protect the rights of others. So even the right of life is limited by self-defense. You can kill in self-defense. And those rights are limited in the interests of preserving the integrity of the human community. But here, because we're recognizing other beings, human rights must also be limited in the interests of the Earth community as a whole, and not just in the interests of other human beings. And the other important thing I think to appreciate is that different beings have different rights. In other words, we're not talking about, sometimes you see people saying rights of nature is about giving human rights to nature. It's not about that. It does recognize that beings are diverse, and although there may be some common rights, as Thomas Berry said, trees have tree rights, insects have insect rights, rivers have river rights, and mountains have mountain rights. In other words, some of the rights that are fundamental to humans would be of no use to a river or a tree. So it's important to recognize that there is a diversity. Of course, the other perhaps most important implication is that because we humans are in a sense like a leaf on the tree of life, we have been produced by the same evolutionary processes that have produced everything else we see around us and that have created the community of life. If we are going to assert that we, this leaf, have fundamental rights simply by virtue of the fact that we exist as human beings, in other words, we have these rights regardless of our courts or our legislature attempts to deny them, then it's a little bit nonsensical to say that the rest of the tree doesn't have the right to exist, which is the current situation, because it's very clear that if you want the leaf to flourish, the branch must flourish, the tree must flourish, the roots must flourish. And so we can't protect and uphold human rights without recognizing the rights of nature, and in particular our duties to the other than human world. So to give a specific example, our constitution in South Africa, like many, recognizes the right to life. But in a dry country, recognizing the right to life in your constitution will not protect you if there's no water. The right to life is meaningless if there isn't water. And if you want to have water, you need to protect the whole hydrological system. You need to protect the forest right to exist, the right of the river to flow, and free of pollution, etc. And essentially, that whole hydrological cycle, we have duties to respect it and protect it, so that there will be water, consistent flow of water, and that in itself is necessary for human life and all the rights that flow from it. So you sometimes hear people talking about co-violations, and there have been attempts to map situations in which there have been simultaneously a violation of human rights and also a violation of the rights of nature. Now, in a certain deep sense, of course, in any degradation of the earth as a whole, the rights of the whole are also degradations of human rights. But I think one of the interesting things is that one finds typically that there are that the correlation between gross human rights violations and rights of nature violations are very strong. The same exploitative, domineering way of thinking, which gives rise to the destruction of nature, is very often also reflected in how people treat other people. So there's a very close correlation, I would say, between protecting the rights of nature and protecting human rights. So in conclusion, perhaps I'd just like to say, as following on from also what the other speakers have also said, that although the human right to a healthy environment is a very important step forward, as David Boyd has said, and is certainly to be welcomed, that right to a healthy environment cannot be protected. In other words, it cannot be sustained and upheld unless we also recognize our duties to recognize and protect the rights of nature, because human well-being is derived from the whole. Everything that we need for well-being comes from this community of life that we call Earth, and we can't expect to continue to enjoy those privileges without also protecting the source from which it comes. So ultimately, the human right to a healthy environment must be supported and underlain by a recognition of our duties to protect and preserve the whole. And that involves, in my view, recognizing and upholding the rights of other beings, in other words, the rights of nature. Thank you.
Thank you, Cormac. Yeah, it seems like we're getting to the same place through a different mechanism ultimately, because we have to. Everything is interconnected. It's obvious in a way. So let's move to Anna as our final speaker. And I would just like to introduce you briefly. She's an environmental lawyer from Georgia. She holds a master's degree in environmental law from the University of Dundee, where she studied there as a Chevening scholar. Her areas of expertise include environmental regulation and international climate change law. And Anna is currently working as an environmental human rights analyst at the Georgian Young Lawyers Association. So I will pass to you, Anna. You've shared your screen, that's great.
Thank you, Lisa. Hello, everybody. First of all, I want to thank the organizers of this webinar for providing me with such an amazing opportunity to speak about the right to a healthy environment from a Georgian perspective. And today I will be speaking about this right, how it is guaranteed under the Constitution of Georgia, and I will be focusing on the problems regarding environmental enforcement and environmental procedural rights. And in order to demonstrate what kind of problems we are facing on practical level, I will be discussing one of the cases I worked on at the Georgian Young Lawyers Association, which is the Namakhwani Hydropower Plant Cascade Project. So to begin with, as we all know, the world is facing the triple planetary crisis, which is worldwide pollution, biodiversity loss, and climate change. And of course, Georgia is no exception in that regard. We are experiencing high levels of air pollution, for example, in big cities or in industrial cities like Tbilisi or Rustavi. And we also are facing some problems with water pollution, which is a result of improper waste management, wastewater treatment, and different business activities, mainly mining activities. For example, in the Chiatura municipality, which is the western part of Georgia, the water, the river Gvirila specifically, is heavily polluted, and that affects the well-being and the health of the people who are living there. We also experience biodiversity loss and climate change. For example, we have more and more seasonal fires. This year we had huge fires in the Borjomi Gorge, and we also experienced the frequency and severity of different natural disasters like floods, droughts, landslides, and so on are also increased. So in this context, it is very important for Georgia, for Georgian citizens and the population of this country to be able to fully enjoy the right to a healthy environment. So this right is guaranteed under the Constitution of Georgia. Specifically, Article 29 of this Constitution states that everyone has the right to live in a healthy environment and enjoy the natural environment. On top of that, the Constitution of Georgia also refers to the interests of future generations. That means that it also refers to the sustainability principle, which is very important from climate change perspective and from the whole triple planetary crisis perspective. Under this article, the environmental procedural human rights are also guaranteed, like it states that everyone has the right to access environmental information and to be engaged in the decision-making regarding environmental matters. Under the Constitution of Georgia, we also have the right to access justice in case we think that our fundamental human rights or our environmental human rights are violated. But what drives the change in environmental field in Georgia are our international obligations undertaken under different environmental and human rights treaties, conventions, and agreements, and more specifically under the EU-Georgia Association Agreement. It is the objective of Georgia to join the European Union, so we have undertaken a number of obligations, including environmental obligations, to harmonize our legislation with the EU legislation, and it also includes the implementation of European Union directives in Georgia regarding environmental matters. So there are some positive changes made from a legislative perspective, because a few years ago we did not even have environmental impact assessment code or forest code, but now we have them, and they are very important parts for ensuring environmental protection and the rational use of natural resources. And we are also working on developing and implementing EU water directive on national level, and we also have just started working on drafting climate law. So there are some positive changes from a legislative perspective, but we face a number of problems when it comes to the proper environmental enforcement and the enjoyment of our environmental procedural rights. So to start with the environmental enforcement, we still have weak institutions in Georgia in general, not just in environmental sphere, and that was the result of some chaotic reforms which took place in Georgia after the collapse of the Soviet Union. And because of these reforms, for example, in environmental field, there were a number of changes in the powers and structures of the state agencies who are responsible for environmental enforcement. So if with the good governance principles like transparency, accountability, and so on are still to be implemented. For example, if we focus on the Department of Environmental Supervision, which is the main agency responsible for environmental supervision and control and environmental enforcement, their work is not as effective as it should be. There are some reasons. They lack human, financial, and technological resources, and their information collection and reporting systems are also not well developed. They also lack knowledge and skills, and from their reports, it can be seen that they are more focused on detecting illegal use of natural resources rather than monitoring the compliance of industrial activities with the granted conditions of the granted permits and licenses. And they mostly use, for example, administrative fines as the sanctions, which might not be an effective mechanism to prevent environmental pollution, harm, or remedies the harm. So they are like business costs for these regulated facilities, and they might not be effective in practice. So in this context, it is very important to strengthen the capacity of the Department of Environmental Supervision in Georgia, and they need more financial, technological, and human resources to effectively monitor and control the activities of the regulated facilities, because in practice, exactly these regulated facilities are the ones who harm the environment the most and pollute the environment the most. But on a positive note, Georgia has recently adopted the law on environmental liability, and I believe that this can encourage the enforcement agencies to use their powers more effectively and to use other forms of, for example, administrative sanctions rather than just imposing fines, which are not effective. We have some problems also with enjoying our environmental procedural human rights, like right to access information, to be engaged in the political decision-making process regarding environmental matters, and to access the justice. And in order to demonstrate what are these problems, I will be speaking about the Namajuani hydropower plant project. I worked on this project at the Georgian Young Lawyers Association, and there were a number of fundamental human rights and procedural environmental human rights violations. So this is a hydropower plant cascade project, which consists of two hydropower plants, the lower Namajuani HPP and the upper Namajuani HPP. It is meant to be implemented in the western part of Georgia on River Rioni, in the Rioni Gorge. On February 28, 2020, the Ministry of Environmental Protection and Agriculture of Georgia granted the company, the Anchor Renewables, an environmental permit on this project. The ministry issued this decision with several procedural human rights violations. Specifically, the company, the Anchor Renewables, failed to conduct and provide at around 30 different studies on the project's possible environmental and social impacts, which were required under the Environmental Impact Assessment Code of Georgia and under the scoping opinion issued exactly by the ministry. These studies were, which included the studies, for example, on seismology or on the impacts on biodiversity, were essential in order to properly define and assess what kind of risks the project might pose to the human life and health, to the environment, cultural heritage, material values, and defined what measures are to be implemented in order to avoid these risks or mitigate them. And in order to conduct cost-benefit analysis and decide whether to grant an environmental permit or not. But although these studies were not conducted and provided by the company, the ministry still granted the company the environmental permit and permitted to start construction works of this hydropower plant. Because of these violations, the civil society organizations and the people who live in the Rioni Gorge started protesting this project, and the situation escalated in that regard. So the local population and the civil society organizations and other environmental experts expressed their fears and concerns about the safety and rationality of the project. Specifically, the hydropower plants are to be constructed in a seismically active area where there is a high risk of earthquakes and landslides. For implementing the project, over 600 hectares of land and forests are to be flooded, which might change the microclimate in that area and disrupt natural ecosystems, contribute to the loss of biodiversity, and affect unique Georgian grape varieties. Damming the River Rioni, which is the habitat of the world's only population of Colchic sturgeon and some other of the last populations of 5 other endangered or critically endangered sturgeon species, that this project might have negative impacts on their populations and decrease the populations. So the environmental and social impacts of this hydropower plant were not also assessed in climate change context. Georgia is already experiencing the negative impacts of climate change, and it is very important for this project to assess what kind of impact climate change will have the availability of the water resources, for example, in Rioni River, in order to assess what kind of effect it might have on the productivity and efficiency of this hydropower plant. In this process, we experienced problems with accessing information. For example, it was actually very hard for us to get the information, for example, which studies did the company conduct and submitted and which they did not, and what were the results of these studies, in order for us to know what kind of environmental and social impacts to expect. Also, there were problems with the engagement of public in the environmental decision-making process. Specifically, the public hearing regarding this project was held 50 kilometers far away from the project area, and it was held at 9 a.m. in the morning, and people needed like 2 or 3 hours to get there because of the because there was limited access to transport. And many of them even did not know that this public hearing, there was this public hearing. And those who managed and attended this public hearing, their questions and concerns largely stayed unanswered. So we believe that there were a number of violations of the rights to access the information and public participation. We have also challenged the legality of the environmental permit, Georgian Young Lawyers Association with another one, non-governmental organization, which is called Green Alternative, and we filed a suit to the court and it was based on the fact that the company failed to conduct and provide these studies. But we filed this lawsuit in 2020, April 6, and still the court has not scheduled a single hearing, even a preparatory one. So we believe that we have not effective judicial system when it comes to environmental matters. So because of the protest from the population and civil society organizations, who we are protesting this project during days and nights. They even have tents where they were spending nights. The situation really escalated, and the state started to use police force and unlawfully restricted our freedoms to movement. They constructed metal barriers on the main road in the Rioni Gorge, and they also violated the freedom of assembly because they removed the tents from that area, and people were not able to continue their protests in the project area. But because the situation escalated, the state invited the EU energy community to mediate process between the government of Georgia and the affected populations, and we demanded in this process that all the environmental and social impacts of this project to be fully assessed, and for the independent review of the commercial and environmental terms of this project. But in the middle of this pre-mediation process, the company, the Anchor Renewables, terminated the contract with the government of Georgia, so we were not able to get our independent reviews and assess whether this project was environmentally and socially sound or not. But under the Georgia's National Energy and Climate Plan, this hydropower plant, Namahuani hydropower plant, is still meant to be constructed in the future. And if this actually happens, we will be demanding from the government of Georgia to fully assess the environmental and social impacts, and to demand from the company to fulfill its obligations under environmental regulations and laws in Georgia. But to end on a positive note, I do believe that some positive changes are still made from environmental perspective, and I also believe that many people are becoming more interested in environmental matters, and they are becoming more sensitive to these matters. And I do hope that with the help of our international partners, we will be able to stress the government to fulfill its obligations undertaken under different environmental and human rights conventions and agreements, and under the EU-Georgia Association Agreement. Thank you. And if you have any questions, I will be happy to answer them. Thanks.
Thank you so much, Anna. It's fascinating. I mean, partly because it really demonstrates how difficult it can be in so many countries, even to get existing environmental laws properly enforced when governments are not putting enough money into that enforcement, or not taking it seriously enough, or whatever. But let's move to, we have quite a few questions. I'd like to, well, my time, it's 4 p.m. So I'd allow, I guess, 20 to 30 minutes for Q&A. So we've got plenty of time if the speakers are all right with that. We have, the first question was from Laurence, and I'm going to apologize in advance if I get anybody's name wrong, because I'm sure I will, but anyway, I'll do my best. Laurence Taillet says, what do you think is the potential of the right to a healthy environment to acknowledge the mental health effect of environmental degradation? So, for example, eco-anxiety, solostalgia, I'm not sure I know what that is, eco-paralysis, etc. What do you think could be the legal consequences of this link? So this is an open question. Would any of the speakers like to take that one?
Well, I'll jump in and then others can join me. I think it's a really interesting question. And in fact, there are already cases before courts around the world where evidence of the mental health impacts of the environmental crisis are being brought forward. And I think, You know, this is particularly troubling in terms of young people. There was a study published in The Lancet a few months ago, which surveyed 10,000 young people between the ages of 15 and 24 around the world, and found that young people are really, really scared about their future, and understandably so. So, for example, in the case that was brought by Greta Thunberg and 15 other young people to the United Nations Committee on the Rights of the Child, those 16 young people put forward substantial evidence about the impacts of the climate emergency upon their mental health. And similarly, in a case that's currently before the Grand Chamber of the European Court of Human Rights, Duarte Agostinho and others, which is a case brought by 6 young Portuguese people, they have also provided substantial evidence in their case against Portugal and 32 other European states about the impacts of climate change on both their physical health, but also on their mental health. And I have to say that I recently did a country mission to Portugal, and it's really striking to see the impacts of the climate crisis in that country. I mean, we think about small island states and drought in Africa, etc. But Portugal, over 1,000 people were killed in July of this year in a heat wave. 100% of the country when I was there was experiencing severe or extreme drought conditions. And it really is, for young people in Portugal and around the world, these mental health impacts of climate change are really another pandemic that we need to address.
Mm-hmm. Indeed. Cormac, you have your hand up.
Thanks, Lisa. Yes, I very much agree with what David is saying. And I just really wanted to add that, you know, eco-psychologists have for a long time pointed out that traditional psychology deals with what somebody referred to as the skin-encapsulated ego. In other words, that the traditional psychologies look very much at what happens, you know, within the body, within the individual mind, and it broadened a little bit with maybe family constellations, etc. But now it's very clear, if you come from the perspective of humans being part of nature, it's very, very clear that many of our most important relationships are between ourselves and other than human beings, and it may be with place, solastalgia, it may be actual conditions, you know, where we feel alienated from nature, etc. So I think what has happened is that our misperception that we are separate from nature has obscured, has prevented us seeing something that's very, very obvious, that it's not just our physical health that is derived from nature, also our mental health is very much derived from nature. So I agree with David. I would see this as a natural progression as we gradually move away from we gradually remove the veil of ignorance which obscures the fact that we're part of nature.
Any of the other speakers like to comment on that point? No? Okay. So thank you, Laurence, for that question. The really important one. We'll move on to Zoe Lujic, who has a question for David specifically. Is there any way that your office can help with the court cases in the countries where there is no amicus curiae recognized or allowed, such as in Serbia?
Yeah, I mean, if it's not permissible for international organizations or individuals to engage at the domestic level, then really the only assistance that we could potentially offer would be to file an amicus brief, either once domestic remedies have been exhausted. So once the national court system of Serbia has dealt with a case, we could then, if the case was then brought to the European Court of Human Rights or to a UN treaty body, we could intervene there. But which we've done. So which, you know, in 3 of the cases before the European Court of Human Rights on climate change and human rights were involved. And as I've mentioned, in a number of cases before UN treaty bodies. But if we're not allowed in the domestic legal system, there's not much we can do. I should also just clarify when we talk about my office, that my office consists of myself as a volunteer and 2 people in Geneva who work for the Office of the High Commission for Human Rights. So we're not a particularly large team.
Make sure I'm not muted. Yeah. So thanks, Zoe, for that question. Sorry, it wasn't a more hopeful answer, maybe. So Maleka has asked, what are the short-term, mid-term, and long-term policy of the UN concerning the human right to a healthy environment?
Okay, well, that's probably another one that I should tackle. And so I think that, first of all, it's worth clarifying that these UN resolutions from the Human Rights Council and the General Assembly are not legally binding or enforceable resolutions. They're a form of soft law. But they are intended to serve as a catalyst for accelerated state action. And although these resolutions are very new, we can look back in time to 2010, when the most comparable resolutions were adopted by those two UN agencies on the rights to water and sanitation. And we can say, look, what's happened in the ensuing 12 years? And I think it's actually quite optimism-inducing to see what's happened. Quite a few countries have added the rights to water and sanitation to their constitutions. Costa Rica, Fiji, Slovenia, and others have added those rights to their highest and strongest form of law. So that's an important step forward. And I think other nations have changed legislation to incorporate the rights to water and sanitation, from France to Colombia. And I will say that during the COVID-19 pandemic, that actually saved lives. So for example, in Colombia, because of the recognition of the right to water, the government adopted a law preventing utility companies from shutting off people's water supply for non-payment of their utility bills. So, in the pandemic, that was a critically important step. Most importantly, however, I think the UN resolutions on the rights to water and sanitation have been a catalyst for greater priority being placed on the fulfillment of those fundamental human rights. I can give a couple examples that I've come across in my work. One is Mexico. Mexico changed its constitution after the rights to water were recognized by the United Nations, and then created a program to focus on people in Mexico who were not being reached by water and sanitation services, primarily rural communities. And in the last decade, this is quite an amazing statistic, over 1,000 rural communities in Mexico have gained access to safe drinking water, which for many of us, we turn on the tap, we take water for granted. But for communities that have not historically had access to water, that is a life-changing improvement. So that's really exciting. And in Canada, where I'm from, I think to my considerable embarrassment, Canada was a country that we actually opposed recognition of the right to water at the United Nations for many years. But once the resolutions were adopted in 2010, we did a 180-degree shift in our position. And in the past decade, Canada, in partnership with Indigenous communities, has ensured safe drinking water and proper wastewater treatment infrastructure for more than 130 remote Indigenous communities. So that's, again, an incredible accomplishment, and I think speaks to the potentially transformative impact of these UN resolutions. So I'm cautiously optimistic that we'll see a similar cascade of action flowing from these UN resolutions on the right to a clean, healthy, and sustainable environment.
Indeed, and hopefully fast.
Yes.
We need that. So another question for you, David. Question for Dr. Boyd from Harry Balfour-Lynn. I understand that the process for recognition of the right to a healthy environment at the UN was led by a coalition of 5 states. I wonder if you could talk a bit about your engagement with that coalition, how it came about, and whether you think an equivalent coalition of right to a healthy environment friendly states might be possible at the Council of Europe.
Sure. So in fact, the mandate at the Human Rights Council on human rights and the environment was created by a group of 5 states: Costa Rica, the Maldives, Morocco, Slovenia, and Switzerland. And those states which created that mandate back in 2012 were really the drivers of the processes, both in Geneva at the Human Rights Council and in New York at the General Assembly, to achieve the resolutions recognizing the right to a healthy environment. Those states did a tremendous amount of diplomatic work to get those resolutions across the finish line. It was not an easy task. There were big, powerful states that were opposed to the recognition of the right to a healthy environment. I should also say that in the resolution at the Human Rights Council, no states voted against the recognition of the right. 44 states voted in favor and 4 abstained: Russia, China, India, and Japan. At the General Assembly, we had 161 states vote in favor, again, none opposed, and 8 that abstained. So really tremendous global support, not quite universal, but close, for recognition of this. And that's a testament to the extraordinary diplomatic efforts of the 5 states that I mentioned, along with allies such as Fiji, the Marshall Islands, Germany, Portugal, and others. In terms of the Council of Europe, I think that there is the potential and the need for a similar coalition of states. I spoke to the Committee of Ministers about this proposed additional protocol on the right to a healthy environment back in February, and I was really pleasantly surprised by how wide the support was. But there's a difference between supporting an idea and actually championing it. And what this additional protocol at the Council of Europe on the right to a healthy environment really needs are champions. So I've been reaching out to states, I've had some very promising conversations with Monaco, with Portugal, with Slovenia, with Germany about becoming champions for this idea. And so I think that bringing those states together that have expressed an interest in being champions is probably a good next step. And I should also give a shout out to Iceland, which was mentioned earlier, and also Georgia, which has been really, the government of Georgia has been very prominent in pushing this agenda forward as well.
Thank you, David, and also to Harry for the question. So there's one question which is slightly unrelated to this, so I'm going to skip over that one for now and just carry on with the questions that are more focused on the topic. But Shakan has asked, so I'll come back to that if you don't mind, Shakan. A question for Cormac. As a human right to a healthy environment is violated more than other rights, at least in Fidan's country. And Fidan is asking, what do you think? What's the motivation behind that? So why is that the right that's the most violated? Maybe the sanction of level of awareness. Fidan, you might want to, if you're there, just say what you mean by that last sentence, unless Cormac's fine with it.
Yeah, I think it means the sanction or level of awareness. I think it may be a typo.
Or yeah.
It's a good question. I think that it probably, I don't know the country, but I think it probably reflects the long-standing cultural assumption that humans are more important than anything else. I mean, so in other words, it's not as bad if you hurting a human being, then that's bad. If you're hurting a tree or a river, then that's not so bad. And I know in this part of the world, for a long time, it was very difficult when one came to wildlife crime, because poachers or people were prosecuted would often be before magistrates in rural areas, and they would say, okay, well, you know, we know that if you assault a person, that the maximum fine or a typical fine you get is so much, and so whatever you do to an animal should be less than that. And essentially, you would get a situation where very low fines were imposed in relation to wildlife crimes, which were completely inadequate to deter those crimes, because you know, the value of the animal, the ivory or whatever it was much higher. So that was definitely, they had to embark on a process of training magistrates around this. So I think it probably is related to the belief that in a way the world is objects, which are, or resources, if you like, which are available for human exploitation, and that we're entitled to do that, and that therefore it's not so bad it's not as bad as hurting a human. And this is one of the reasons why it's important, I think, to shift to a more ecocentric perspective, where one realizes that we're part of a community of life, and that everything has got its role to play, and must be respected for that. I mean, everything that exists has come into being through a process of evolution, and the fact that it's still here shows that it's playing some role in the whole. So I think it's both a product of perception and understanding, and particularly objectifying all that other than humans, and with that perhaps the sanction. You know, that it's also true that these things are not enforced in the same way as so, you know, murdering a rhino is not the same as murdering a person in the same scale even. And I'm not trying to diminish the significance of murdering people, but I'm just trying to show that we are brought up to think in a very anthropocentric way, which doesn't necessarily reflect the reality that at this point in human history, loss of biodiversity is extreme, the threats to humanity, etc. And the one thing that we can't afford to do is continue with business as usual. We have to change not only how we behave, but also our worldviews, because our worldviews and values is what drives our behavior. Thank you.
Absolutely. Thank you, Cormac. Would either Sue or David like to comment on that point, that question?
No, thanks.
No? Okay. So we have, for David again, I was wondering, as someone very involved in environmental law, if you had an opinion on the Fairy Creek blockade close to Vancouver, and whether deforestation of old growth forests will become unlawful in the near future. This is Sanya Katic. Yeah.
Right, thank you. Yeah, the Fairy Creek blockade is actually very close to where I live here on the west coast of Canada, and it is an area of absolutely magnificent old growth forest with all of the wild species that call those forests home. And I think that here in the province of British Columbia, the overwhelming majority of old growth forest has already been logged off. So it's critically important to protect what's left. We don't have legal recognition of either the rights of nature or the right to a healthy environment in British Columbia or Canada, which surprises some people. Those tools would be helpful in this context. And I think that at this point in time, there are courts around the world that have found deforestation to be a violation of the right to a healthy environment. In Colombia, as I mentioned earlier, in Brazil, in the Philippines, one of the leading cases on the right to a healthy environment was a Filipino case from the early 1990s, where an amazing lawyer by the name of Tony Aposa brought a lawsuit based on his children, or on behalf of his children, claiming that the logging of old growth forests in the Philippines violated their constitutional right to a healthy environment. And the Supreme Court of the Philippines found that it was indeed a violation of their right and the rights of future generations. So that's one of the most important court decisions in the world, was from the Supreme Court of the Philippines. So yes, the short answer is yes, deforestation is a violation of both the rights of nature and the right to a healthy environment.
Mm-hmm. Thank you, David. We have one more question. We have about 10 minutes left. So we have Danny Spizicino from Stop Ecocide in Italy, who has also a question for David. If in the process of promoting the resolution at the HRC, there were talks with the working group who is drafting the Treaty on Business on Human Rights, this is to know if there was or is any discussion on corporate behavior as regards the human right to a healthy environment at the HRC.
Yep, very much so. So it's true so I want to just take a step back and say corporations are responsible for a huge amount of the environmental degradation that is impacting upon both human rights and the rights of nature. And so we have to find stronger legal tools to deal with corporations. Right now, at the global level, we have something called the United Nations Guiding Principles on Business and Human Rights. It's a voluntary instrument and it's completely ineffectual. So there is a need for something stronger. That's why there are negotiations ongoing for a legally binding treaty on business and human rights. Those negotiations, to be honest, have been difficult and are still struggling to move forward. The current draft of that treaty, however, does include specific mention of the right to a clean, healthy, and sustainable environment. So there is recognition that corporations are responsible for a large proportion of the violations of that human right. And I've just begun working on a report that will be presented to the General Assembly in October of 2023, which examines the relationship between business activities and the right to a clean, healthy, and sustainable environment. I think this is one of those issues where we need systemic and transformative change. Corporations were created hundreds of years ago. The idea of a corporation to pool capital to do things that individuals couldn't do. That is no longer really, corporations, in my view, are no longer really fit for purpose, except for a small subset of corporations, which are called benefit corporations. And this is a new legal terminology, which corporations have to qualify to be able to use that term. And benefit corporations, instead of being beholden only to their shareholders, beholden only to maximize the profits of their shareholders, benefit corporations have to have a public benefit as well. to their workers, to society. And my question is, why aren't all corporations benefit? Why do we have benefit corporations on one side and detriment corporations on the other side? So I think we really need some fundamental rethinking of corporate law for the 21st century.
Exactly. And I think I'm just remembering a movie that some of you may have seen called The Corporation, which it sort of highlighted how the behavior of corporations, if you look at what a psychopathic individual is like, that is reflected. I'm sorry, my dog is really bugging me. She wants to be fed. So the behavior of corporations it's very similar in many ways to how psychopathic individuals behave. So I think, yes, you're right. Why do we have detriment corporations at all? So yeah, that needs an overhaul. So we're almost at the end of our questions here. We have Hussein has a question for Anna. He says, is the environmental law in Georgia working? Are there a lot of cases or are there dead norms?
Thank you for the question. Yeah, as I already mentioned, we're developing our environmental legislation, different laws and regulations, water directive, forest code, and so on. But in practice, yeah, we are facing many problems. For example, when we take some cases to the court system is not a very effective mechanism because there is a long process to deliver the justice, for example, to make the decision, to take the decision from the court. And the people and the enforcement agencies, they are not still very sensitive to environmental matters, and they prefer short-term benefits like economic benefits rather than taking care of the environment. But yeah, we experience many problems with the implementation and enforcement of environmental laws. But in the near future, I do believe that we will advance the environmental field.
Thanks, Anna, and thanks, Hussein, for the question. So I'm going to scroll back to a question that Jacqueline had for Sue. And it says, I have a question which is not related to the main topic. Could you please talk about the practical problems or aspects of working at King's in the legal centre for students who want to pursue their higher education there? Thanks in advance.
I suppose one of the things we haven't spoken about is access to justice, access to environmental justice. And, you know, that's one of the difficulties that communities face. First of all, there's the difficulty about the lack of rights, but then there's also the difficulty that if you're an Indigenous community in the Amazon, it's hard to find any way of getting legal advice and support. So at the moment, there's a community in India, in the Sundarbans, which is a kind of river delta near Calcutta, and the clinic's trying to work with an Indian university to provide support in the form of raising awareness through street law and kind of pop-up clinics to that community that's affected by extreme weather events and is being flooded off its islands by the effect of climate change. So what we're trying to do, why I came to the clinic from private practice, was that I was keen on trying to provide access to people who otherwise can't get any access to justice using resources of universities, and legal students, the geography students, they've got a lot of interest in these issues and they have some time, and we can drag in a few academics and external lawyers and thereby try to increase access to justice in some small ways through amicus and kind of non-litigation complaints. And yeah, the students do the background legal research, and we try to provide access to as many students as possible to do that work so that we can take forward these issues. I hope that answers the question.
Yeah, I'm not 100% sure, because it sounds like it was asking if you want to be a student at King's and work at the legal centre, what are the are there practical problems of being there, I guess, as a student? I don't know, that's how I read it, but I'm not 100% sure. I guess living in London is expensive for one thing. That's a practical problem of being a student in many cities now, but certainly in London. But anyway, if Shakan has anything else, you could quickly pop that in the question box if that wasn't quite the answer you were looking for. But maybe we should move, as it's in my time 4:25, perhaps just to move to some closing remarks. If based on everything we've talked about, if any of the speakers just have any sort of final comments and thoughts that they would like to offer to our participants.
Yeah, I think it's come up in a couple of questions, the issue of corporations. I think if we want to achieve, rights of nature, environmental justice, right to healthy environment, we have to use as many different strategies as we can, but certainly there needs to be greater regulation of the power of corporations, their economic power, and that's why there's damage to the environment, whether damage to nature or humans. In Europe, there's a proposal about a due diligence right, which would require companies to have due diligence for human rights and in relation to the environment. There is the ecocide proposal that companies should be prosecuted for extreme human rights violations, but I don't think that we can succeed in obtaining a right to healthy environment without some greater regulation of and accountability of corporations. Thank you.
Thank you, Sue. Any of our other speakers like to give a final word?
Perhaps I could just support what Sue and David have both said in relation to corporations. And I think, for me, it's particularly extraordinary that humans have made up these fictional creatures and have really given them a huge impunity for what they do. So you have a situation where, mountains of millions of years old, forests, extraordinary diverse life are seen as resources, as objects available to be commoditized and used, and with no rights. And then you'll get, something that is abstract as a corporation, which is given extraordinary rights and really very limited responsibility, particularly for the humans behind the corporations. I think you have a situation where they're often a device for humans to avoid responsibility. And if you look at indigenous systems throughout the world, there's a huge emphasis on respect for nature and other beings, but also responsibility, and responsibility both personally and collectively. And I think that dealing with corporations is part of reasserting that we have, the pendulum has swung too far in favor of our entitlements as humans, and needs to swing back to much greater acceptance of that. As particularly gifted members of this community of life, we also have higher levels of responsibility to ensure not just that we behave well, but that other humans and other institutions behave as good members of the Earth community and not as destructive rogues.
That's beautiful, Cormac. And I would just say that, both the right to a healthy environment and the rights of nature are concepts that challenge the status quo, challenge it very deeply and profoundly. And at the same time, these rights are just tools, and tools are not going to change the system unless people pick them up and use them. So I would really invite everyone here to use your right to a healthy environment, to support the rights of nature, and to help us in the systemic transformations that we need to become an equitable society that recognizes our familial relationship with all of life on this beautiful planet.
Indeed, thank you, David. And Anna, would you like to say a final word?
Yeah, I will just thank you, the organizers, the speakers, and the participants for this amazing webinar. And I hope that my inputs were also interesting to you. And yeah, let's take care of the environment together.
Thank you, Anna. So I think my final thought, based on everything I've heard, which has been amazing, and thank you everyone who's participated also for the questions, is just also that governments, of course, are the ones that are licensing corporations to do the damage. So then where is the value system or the reins? What is holds the governments accountable to the people? Because obviously the impact on the people is destruction as well as on nature. So it's I mean, it's so everything is so interconnected, obviously. But and then of course it comes down to who do we elect? You know, as we see in Brazil, catastrophic consequences of electing somebody who doesn't care about the forest or thinks it just needs to be chopped down and commodified. So yeah, we're all in this boat together, and as David said, I think, you know, it's incumbent on all of us to take the actions that we can in our own spheres of influence, where we can, to protect each other and to protect the living planet and all the species that make up this incredible community of life. So I'll pass over briefly just to Fidan to close the webinar. Fidan, are you with us?
Yes, I'm here. Thank you, Lisa. First of all, representing Consensus Law Magazine, I want to thank both participants and speakers, especially our dear moderator Lisa for her massive contribution in organizing this event, and partner organizations which are working for a better world. To be totally upfront, I myself learned a lot of things related to ecocentric law, which was a beautiful experience. Also got the chance to meet such sensitive souls and professional lawyers from all over the world, which was incredible. And it's so motivational that many people are interested in rights related to ecology. And I really believe that this webinar series enabled us to exchange our knowledge and experience regarding this vital field of law, which is not only matters for the day, for also tomorrow. And I'm happy to declare that as Consensus, we are gonna make a lot of like these events, webinars, competitions in the future regarding ecology law and other fields of law. So I don't want to make take your time anymore. Thanks for participation again. The videos of this and previous webinars will be on YouTube in a few days, and I would like to invite and encourage you to subscribe our channel and share the videos. And for the first one, the link is in the chat. So once again, thank you so much.
Thank you, Fidan, and goodbye, everybody. Thanks for being here.
Thanks, everybody.
Thank you.
Bye-bye.